Thank you.
Welcome to our committee.
Thank you. To identify myself, I'm Michael Morrill. I'm the Director of the Administrative Rules Office, which is part of Office of Legislative Services. So a little guide to rulemaking, especially regarding your your committee, Environment and Agriculture. Let's start broadly. What is a rule? It's basically a requirement adopted by an agency affecting people outside the rule. It means each regulation, standard, form, or other statement of general applicability adopted by an agency to A, implement, interpret, or make specific a statute enforced or administered by such agency, or B, prescribe or interpret an agency policy, procedure, or practice that's binding on persons outside the agency. There are 10 basic rulemaking principles. They come about mostly from legal cases or directly from RSA 541A, which is the Administrative Procedures Act. Rulemaking is lawmaking with legislative oversight. Rulemaking authority comes only from the legislature, either in a statute or a session law, and it's not inherent with the agency. Rules have the force and effect of law if validly adopted and filed, and if they have not expired, and they shall not be enforced otherwise. Rulemaking may not modify statutory law, that is, the statutes always trump the rules. Rulemaking by agencies is governed by RSA 541A unless exempted. An agency is an executive branch entity. A rule is a rule by what it does, even if it's not called a rule. The example that we give is a legal case, Asmussen versus Commissioner of the Department of Safety, which is over 20 years old. In that case, the department, I think the commissioner was not happy with the rate of findings of guilt for administrative license suspensions. People would have been stopped for that. They will come in for a hearing, and commissioner felt, I assume it was the commissioner, felt that there wasn't a high enough conviction rate. So a memo was put out to all the hearings officers, and they have, I don't know, 6 or 8 hearings officers that hear these cases. And it said the hearing officers shall do certain things. For example, it said if a police officer cannot make it to the hearing, then the meeting would be continued. If the defendant does not show up, then there'll be a finding against the defendant. Well, maybe that's fine in principle, but it wasn't. The only people that knew this were the hearings examiners. And requirements like that obviously affected people outside the department. Someone sued, it went to the Supreme Court, and they said, a rule is a rule, whether you've adopted it or not. And you can't implement it if you have not adopted it through the regular process. And by the way, feel free to interject anytime you want.
Ms. Morrell, Morrell, right?
Morrill.
Morrell.
Yeah.
I'm sorry. Could you introduce yourself a little bit about what office you're from and what your background is before we
Okay.
get into?
Yep.
Thank you.
I'm the director of the Administrative Rules Office, which is part of Office of Legislative Services. I have been here about 31 years, first as a committee attorney, then senior attorney, and then for the last 2 years as a director. I have done both sides because when I was a legal intern back in 85 to 87, I worked for the Department of Safety and helped do their rules.
Thank you.
Some of these basic rulemaking principles came from an opinion of the justices in 1981. The legislature adopted the Administrative Procedures Act, RSA 541A, back in 1973, but it really had no teeth. So the legislature inquired of the Supreme Court as to what they could do. Could they have a committee of the legislature that voted up or down on the rule? And the court said no, because the legislature as a whole had granted the rulemaking authority to the department. To have a single committee say, no, we don't like that rule, we don't think it conforms to legislative intent, then you basically have a pocket veto. So, JLCAR, the Joint Legislative Committee on Administrative Rules, was 2 years later created by statute. It's a statutory subcommittee. It's 5 regular members from the House, 5 regular members from the Senate, and 5 alternates from each body. They are not a policy committee. They are an oversight committee. It can be difficult sometimes for them to switch hats from policymakers to oversight, but they work very hard at that and try not to substitute their opinion for what the legislature has put in statute. Their power is limited in that they can object based on 4 reasons. If they object, they can enter I should stop and go through the process. When an agency wants to do a rule, it will draft up the text. As you know, with the Department of Environmental Services, they often engage people that will be affected prior to the rulemaking or during their rulemaking hearing. When an agency does a rule, it's required by law to have a public hearing. The public hearing is at least 3 weeks after they've published notice in the rulemaking register. The register is something that's put out by our office every week, every Thursday. You should be all getting a copy via email. There has now for over a year been a link in the register so that you can actually look at the text of the rule. After their agency submits their notice, we review it. And before they submit their notice, they have to go to the LBA and fill out a form for the LBA saying what the costs and benefits of the rule are. And the LBA then uses that information to publish a fiscal impact statement, which the agency files with us as part of its notice. The rulemaking notice form, which explains the rule, says when the hearing is, says when the written comment deadline is, and includes the fiscal impact statement. Then they have their public hearing, which, as I said, is at least 3 weeks later. They usually post that on their own websites, but there is no requirement to post it any place but the rulemaking register, which I think personally is not the best way because most of the public does not get the rulemaking register. They are also obliged to notify anybody that has informed them that they would like to be notified of any rulemaking in a given area. So then the agency has its public hearing. Sometimes they have more than one if it's a really hot topic. Education has got a couple of rules right now that there's a lot of public interest, and they had a couple of hearings on one of them. DES occasionally does that. They can either do it twice during the formal process, or they can have a pre-rulemaking hearing. They take that input and draft a final proposal based on public comments and based on comments from my office. We make comments on everything from grammar all the way to constitutional issues. We look particularly at the 4 bases for that JLCAR can object to, which are authority. Does the agency have rulemaking authority? Legislative intent, which is a big one. A lot of the comments we make about legislative intent involve conflicts with RSA 541A. If they've missed a step that they're supposed to take under that statute, we'll make a comment. If the rule is simply unclear, well, there's a requirement in 541A that it be clear. They're also required to comply with the rulemaking manual, which is about a 175-page manual that all agencies have to follow, because it's supposed to be a uniform set of rules. So if you went from one agency to the other, you would know generally how to find something and how it would be written, instead of having over 100 different methods. It's sort of like writing statutes. They're all fairly uniform. Committee can also object based on public interest. And you say, well, how can they do that if they're not a policy committee? They can do that because in their own rules, which is attached to the rulemaking manual, they are very limited in what they can do for contrary to public interest. If the rule is unclear and people can't understand what it says, then it's contrary to public interest. If the rule can't be uniformly enforced, then that's contrary to public interest. There are other couple smaller ones. The final basis for objection is a violation of the fiscal impact statement. In other words, the fiscal impact statement says A, B, and C are the costs and D is the benefit of the proposed rule. Well, they forgot to mention the fee they've put in the rules, which obviously is going to have an impact, but particularly if it's a new fee. And after the final proposal's drafted and submitted to us, we also review the final proposal. Every time they file with us, we review at least twice to make sure we haven't missed anything. We still do, but we do the best we can. So based on our comments and the public's, they draft their final proposal, they submit it to us. They have up to 180 days to file the final proposal, so they can take quite a while to do it. That amount of time is really needed because of some of the boards. There are boards in the state that only meet once every 3 months, so it's difficult for them to go through the rulemaking process in statutory time.
And Representative.
Yeah, I just wanted to, because I want to write.
Representative Germana, 1 second for a question. Go ahead.
Thank you. And I hope if it's better to have this question answered later, let me know. But I'm curious about learning more about legislative intent and what that entails, because you're talking about an executive department, and an executive department, right, is subject to the political pressures of the executive. But I'm interested in how legislative intent is ascertained, right? Because you've got the legislation that is on the books, but then you also have, for example, a clear history in this case of this body being on record, for example, with regard to landfill siting. These are bills that were vetoed, for example, by the governor, right? So I'm just curious about like how specifically legislative intent is discerned.
I was going to do that after the general overview, if that's okay.
Yes, thank you very much.
Okay.
Mine is just about
Okay, go
this. So time frame wise, I just want to, if you can just succinctly, so we're looking at, the notice goes out,
Yeah, once they file the notice with us, the clock starts.
and that notice was, we were all just noticed of that.
Yes.
Okay.
And
And
they have to wait at least 3 weeks before they can hold their public hearing.
Yep.
And
So,
then they have to wait at least another 5 days, generally speaking, to accept written comment.
okay, perfect. So notice, clock starts, 3 weeks of public, for the to the public hearing notice.
Yep.
Okay, and then, public hearing takes place.
Correct.
5 days to written.
Generally, that is. Technically, boards and commissions can vote on their final proposal at the end of the public hearing process. Most, because of past experiences, try not to do that because it raises the question, well, how much are you taking into account the public testimony
Correct.
if you've already got the final proposal drafted? That has run into problems before,
Okay,
but
so, yeah, so I'm thinking, so public hearing to final proposal, that's the time frame. So what are we looking at there? 180 days.
yeah, it depends on the agency. Most of them will file within the final proposal within a month or two of the public hearing. Sometimes it'll be within 10 days of the public hearing. It depends on how rushed they are, how long the rule is. The rule could be a sentence or it could be 100 pages.
Well, I was just going to say, and in this case, it's very long. My other question is, okay, so, and I have a bill in, which looks like it's going to pass, which is fantastic, that changes this a little bit, that gives, public testimony, the emphasis kind of that it needs. So for example, requiring, which is kind of what we do here in the legislature, but it makes the agencies post their stuff onto their website and any of the written that they could do, that whether it's emailed to them or scanned in, which was fantastic. So it looks like it's going through, which is wonderful. I was just checking on it actually, because I think it's going to be an exec today. So that won't apply probably for stuff that's going on right now. But so after the public hearing, I do know that the comments on each, let's say, substantial thing, is that in that 180 days? Because my bill changes this a little bit, so that's why I'm trying to understand. Right now, it's really not defined.
Yep. It would, yes. Right now, as of October 3rd of last year,
Yep.
agencies are required to do something that Environmental Services has done for years, and OPLC recently, because one of their attorneys ran the legal unit at DES for decades. And that is every public comment they get, they list what the comment is, they say what change they're going to make because of the comment, or if they're not going to change it, they specify why. And with DES, it could be a citizen, it could be a business owner, it could be EPA. And they go through all of that. And then separately, they do the same thing with the comments that my office provides.
Wonderful. Last question. So the piece that is right now that we're trying that this new legislation is going to help with a little bit is time frame, right? So you have this wonderful public hearing. Let's say there's gobs of testimony, real good stuff, right?
Yep.
And people are kind of like, okay, well, what happens? Now, that's kind of like where there's been a black hole. And my bill is trying to be able to get that up online to the point where, and the response that DES is going to do, so people have enough time to kind of see where that's at
Yep.
before it goes directly. Sometimes it's only 5 days before it's going into like JL Carr, and that's a huge issue.
Yep.
So to be able to have that, kind of the public testimony up and the responses back, so it's more transparent, because the public is, it's hard sometimes after you testify at a hearing, even here, on the House side and the Senate side, you're kind of like, okay, well, where did that go? What's the process? Having to try to chase down when the next hearing is, or executive session.
Yeah.
I feel as if it's difficult for our constituents, and they're the boss, and so I really that's why this bill was put in. So usually right now, the last time I looked at this, it was about with another agency, in the kind of the response back, it was only like about 5 days. So that's not something right now that you guys can control, correct?
Right. The new process that I just summarized, where they do a summary of the comments, they are required now to file that with their final proposal. So you're not seeing the comments well in advance. The final proposal, once it's filed, it will go on to the next month's committee meeting. It has to be filed at least 3 weeks before a JLCAR meeting in order to be taken up. That's another chance for the public to see what's in there. Because sometimes the changes from an initial proposal to a final proposal are significant. Sometimes they're just minor changes.
Well, that's a good thing. So then we'll be able to, 3 weeks before the first JL Carr meeting, those replies and stuff would have to be live, correct?
Right.
Perfect.
And in fact, in House Bill 1622,
Yep, I'm familiar.
that period of 3 weeks would be lengthened to 4 weeks.
Wonderful. That's very good
So
information.
basically, a month before they go before GELCAR, the agency will have had to file the final proposal with us.
That's wonderful. Thank you so much.
Yep. Okay, the agency has filed the final proposal. As I said, we review that twice. One of the committee attorneys, we have 3 committee attorneys, 2 administrative staff, and myself. The attorneys will go through it, and then I will take another look at it to see if there's anything that was missed. Those comments then go out to the agency. They're available to the public. Agency is required to, if anybody makes a request, they're required to give them copies of anything that's been filed. Initial proposal, rulemaking notice form, final proposal. So we comment it, and then the final proposal goes to GELCAR. When it does go to GELCAR, the agency would be there at GELCAR's meeting, and we would be there. We're their counsel by statute. And we would raise the more significant points to them regarding the rule. We don't bother with the editorial stuff, and we might make a lot of editorial things. Well, you used a period here, and it was supposed to be a semicolon. You misspelled this word, but the committee doesn't want to deal with that. I mean, technically, those things violate the manual, and they could object on, but they're not of importance enough to do that. So the committee listens to the agency and to us. If they're satisfied, and first, the committee's not required to make an objection. There could be something fairly black and white, but there are circumstances outside that they decide not to object. Say DES needs to get a rule in by a certain date, or they're going to lose federal funding. Well, if there isn't anything really troubling with the rule, the committee would probably approve it. They might approve it with a recommendation or understanding that the agency will go back to rulemaking to address those remaining issues. There's also another step after the final proposal. The agency gets our final proposal comments, and they say, oh yeah, those 3 things they brought up, yeah, that's not right. We should correct that. They can then put in what's called a conditional approval. It's basically an amendment to the final proposal. And maybe they got late filed public testimony and they want to do it for that. Maybe they noticed a mistake of their own, or because of one of our comments. If they file one, the committee will take that up with the final proposal. They can conditionally approve the rule, which means the agency goes back and submits the exact changes they said. That doesn't go back to GELCAR unless they don't do it exactly as GELCAR said. We simply review it in my office. If there's no conditional approval, the committee's going to look at the final, well, either way, they're going to look at the final proposal and decide whether to approve, conditionally approve, or enter a preliminary objection. If they enter a preliminary objection, they're saying, well, we think these 3 issues have a problem. We're going to enter a preliminary objection. The agency then has 45 days to come back to GELCAR with a preliminary objection response in which they make changes, or if they don't wish to make changes, then in a cover letter, they explain why it's not appropriate to make those changes. And if the GELCAR enters a preliminary objection, the agency comes back, the committee can approve the rule. If the committee is still not satisfied that they've eliminated the basis for objection, they can make a final objection. But because the committee doesn't have veto power, the agency still can go ahead and approve the rule, adopt the rule over the committee's final objection. The final objection has the effect that if the agency adopts it, the rule over the final objection, then if somebody sues the agency regarding the rule, the burden of proof is going to be on the agency. And if it gets a straight approval from GELCAR, then there's a presumption that the rule is valid, and the person would have to go to court and prove that the rule is invalid. But with final objection, the burden of proof switches. And one final step, if the committee in addition to or instead of the final objection, they can vote to sponsor a joint resolution. That's where they believe there's a really serious issue and they think it needs to be addressed by the entire legislature. There are timeframes for doing that. If it's filed before the session, well, either way, there's a limited time for the legislature to deal with that.
Joint resolution.
They're pretty rare. They used to be common way back when, 25 years ago, because after 28A, Part 1, Article 28A of the Constitution was adopted, it said you can't pass on costs to political subdivisions if you're an agency. And so the committee made frequent objections with DES about that because they said, well, this is imposing a cost on them. But over the last 2 or 3 decades, the Supreme Court has pretty much whittled down the effect of 28A, so it rarely comes up anymore. There was a decision called City of Concord about 10 years ago that
It's ridiculous.
really took the guts out of 28A.
Yeah, go ahead.
Perhaps I missed it, but could you say something about the conditional approval? You said there's approval, there's conditional approval, and there's
Right.
preliminary objections.
Yep.
But could you speak to what conditional approval means?
Okay. You've submitted the final proposal. We have reviewed it, made comments, and the agency said, yeah, we need to fix this. So they asked for a conditional approval. They basically bring up another copy of the text showing further changes to correct the problem. Maybe Jelcar said, well, you don't have authority for this paragraph. So the agency might agree and decide to take out that paragraph. And the committee would look at the conditional approval and say yes or no. And that's basically that process. The conditional approval is filed with our office. We review that just like we do the final proposal and tell the committee whether we think the process and whether the problems have been eliminated.
And at that point, then it becomes approved. Once the conditions are met, then it's approved.
The conditional approval goes to Jelcar, and Jelcar can say, yeah, this cleaned up the issues that were
Goes
raised.
back to jail car for round 2 to
Yeah.
sort out the conditionality.
Yeah, it goes there with the final proposal, and
Okay.
the committee can say, well, between the final proposal and the further changes you made in the conditional approval, then we think the rule's okay. But they can decide that the conditional approval doesn't do enough to eliminate the issues, so they'll do a preliminary objection based on the final proposal.
Okay, thank you.
And most of the rules the agencies adopt are what we call regular rules. Those are valid for 10 years. Agencies, a lot of the rules we get are not implementing new legislation or setting a new policy. They're readopting an already existing rule. And if the rule's 8 years old and their statute has changed, or they really realize they need to change the process, then as part of readopting that rule, they will also amend it. That's the majority of rulemaking. There can be, because of, in the rulemaking register, if you look at the list of new notices that have come in the prior week, if you see an asterisk, then then that rule is implementing new legislation, basically from the last 1 or 2 sessions. And that means that the subcommittees that have been set up to review rules can take a look at that and say, yeah, we think there's a legislative intent problem here. We're going to tell the agency, we're going to tell Jelcar. If the agency doesn't deal with it, then subcommittee could come before Jelcar and state their concerns. Legislative intent can be really hard to nail down. Some statutes that grant rulemaking authority are very specific, and it's easy to tell. Some of them have to be specific. 541A says if you're going to do a new form of license, a new form of fee, a new discipline, then you have to have specific authority in your statute. It has to say you shall develop this new disciplinary measure. If it doesn't, they cannot do that. But otherwise, legislative intent can be difficult because it might not be specific. I know some of the boards and commissions have rulemaking authority. It says any rule necessary to implement this chapter. Well, that leaves it pretty broad and wide open for the agency to adopt rules. And in that instance, it can be very hard for the committee attorneys to say whether something is within legislative intent or not. That can also be difficult for jail card to determine. If we can't see with legislative intent, because first thing you do is look at the wording of the statute. I mean, if it's clear on its face, then that's what's implemented. That's legislative intent. If we can't tell whether the thing the agency wants to adopt in their rules falls within that intent, we'll try to look up the legislation, see what was said in committee hearings, see what was said on the floor. We might even involve the research office within OLS to help us on that. And the agency is free, if we do raise a legislative intent issue, the agency will come to JLCAR and explain why they believe they do have authority. And agencies are pretty good about legislative intent. There are places where they're not absolutely sure and they think what they're putting in the rule is necessary to carry out the program. JLCAR might disagree. There are times when, say, a commissioner really wants something and maybe he's trying to put a square peg in a round hole, and then the committee has to decide on that. Questions?
Representative Jamana.
Thank you, Mr. Chair. And thank you very much for coming to talk to us today. And so this has more to do with legislative intent, and this is one of those kind of, I know, strict constructionist kind of questions in the sense of when we talk about legislative intent, are we talking about the intent of the legislature that passed the law, the RSA, or are we talking about the current legislature?
The courts have said, it's the intent of the entire legislature when they voted. Well, frankly, that's hard to discern sometimes. With as many bills you have to deal with at one time on the floor, the intent of the sponsor might be looked at, but that's not controlling. Neither is the intent of the committee that did the blurb for the House or Senate. Those might be factored in, but so it can be hard to nail down what legislative intent is.
May I follow up?
Yes, please.
Thank you. And because what I'm wondering is, as I said, I understand it's difficult, right? Because these agencies are executive agencies. The heads of the agencies are appointed by the governor.
Right.
But RSA is made primarily by the legislature.
Yep.
And so executive departments are in the situation where they're between those two powers, right? The
Yes.
executive power and the legislative power. And my concern is what happens when rules go forward that the legislature feels do not reflect feedback that it has consistently given to the agency. So if you've had several bills, for example, that have in some cases gone all the way through, been vetoed, to me, that's an expression of the will of the legislature. You've had an oversight committee that has provided feedback. And my concern is what happens if the legislature feels that its feedback has simply not been incorporated into the rules process?
Okay. Smaller part of that first. If the legislature vetoes a bill and then the agency tries to implement that, there's a strict prohibition on it. They cannot do that.
No, the governor vetoed.
Governor.
Yeah,
The
I
bill is
understood.
vetoed.
I understood
Right.
what you meant. Yeah. So so it is one of that. It's trying to discern, if I'm getting this correctly, the intent of the legislature at the time that it passed the RSA that is being interpreted.
Right. Just for an example, I can remember long ago, because the Department of Safety has Marine Patrol, the upper echelon in the department decided we should have an auxiliary Marine Patrol. Well, there was nothing about it in the statute, and so there was a big argument in front of JLCAR as to whether that conformed with legislative intent.
Thank you.
Representative Potenza.
Okay, so to understand, because I'm going to go back off of legislative intent. In a perfect world, how it's supposed to work is there's current RSA, there's a recent bill that was passed, whether it be a year or two ago. Let's say there's rulemaking that is coming up. Rulemaking's not necessarily happening, every 6 months or every year or something like that. Okay, so we're looking at, okay, here's rulemaking's coming, so we're going to go based upon previous RSA that or bills that were passed that became law, within the last couple of years or something like that. Now, when none of that exists at all, we're going to have to, I assume, look back to old RSA, pulling pieces from other things, because in a sense, in a situation that we're in right now, they are kind of going rogue. They don't have anything to base their rulemaking on legislatively, law-wise. Yeah. The bills, as he said, that have gone through have been vetoed. Or maybe killed on the other body or whatever it may be. And so, I'm a new rep, so this is, I only can talk from 23 to 24. But some of this stuff has been going on for 5 or 6 years now, and, even longer in certain things. So to be able to, whatever they're basing their rules on, it should be based upon RSA and through committee hearings and testimony and all of these types of things that where we thought things were headed are not. So our only power is really to go dig through, I assume, old RSA, right? To say, okay, this doesn't match up with this. That's really what we should be focusing on if we have a real problem with certain aspects of rules.
And that can be difficult when a bill passed 20 or 40 years ago. What was the intent of the legislature on that rule? That's why there's a limit on this new process that involves statutory subcommittees of the standing committees to recent legislation. In other words, a year or two out, because there are going to be members on that committee that are aware of that legislation and were around then. But the rulemaking doesn't always happen immediately. We sometimes get rules that are implementing statutes that were 3 or 4 years old.
So from this committee's perspective, I gave you a little bit of an outline. The last 4 months, we've been working with DES to review the rulemaking process.
Right.
The rulemaking process has gone, they've made a lot of changes to the rules which enhance environmental and public safety, but they have not made some changes that people on this subcommittee and in our committee believe are prudent. And so we, as the subcommittee and the larger committee of the legislature, what is our recourse then if we still believe at the end of the day the rules that they have are not as stringent as they should be? From what you just talked about, it would seem to me that we can interject in that 180 days. We get and in the time leading up to the public hearing.
Okay.
Yeah, go ahead.
When the notice is filed with the initial proposal in it, anything that was initial proposal that was filed after October 3rd of last year is going to have that summary of public comments and how they reacted to it. So you'll be able to see that. If in reading the rule you see something, I don't think that conforms to what the statute says, then you can certainly tell the agency, and they can take that into account when they draft a final proposal. If the final proposal comes up and you still have concerns, you can again tell the agency. If they don't do anything further, like conditional approval. You can come to JLCAR and explain your reasoning, and JLCAR may object on that. The other option basically is new legislation to say, do this or don't do that.
Okay. Representative Haskins.
Thank you, Mr. Chair, and thank you for taking my question. So, somewhat of the urgency we are experiencing is because it's a 10-year update of the rules.
Yep.
So, things change, new information comes about.
Right.
Speaking for myself, new legislator that I am, I don't see that the public input is necessarily making its way into the rules. And since I represent the public, I would love some assurance that the public comments, testimony is making it into the rules.
Yeah. I think that summary helps a lot, so you can see clearly whether something did or not. I'll be frank, sometimes public testimony wants something that the agency doesn't have the authority to do. A new small state agency was created recently, the Office of the Ombudsman for RSA 91A, the right to know law. So people, instead of going to court, if they're unhappy with the decision, say your you ask for information from your town, they refuse to give it, you can go to the Ombudsman instead of going to court. I know there was a lot of public testimony when that agency was created and on their rules. And I saw some of it, and people were saying, well, you should be able to do this to the governor. You should be able to do this, which is blatantly unconstitutional. So some public testimony does need to be rejected, but your point is very well taken.
And for a follow-up.
Thank you. I respect that, but we aren't just the public. We are the legislators.
Right.
We are supposed to write the laws. And as this subcommittee is formed to oversee the rulemaking, I am not fully sure that our comments have made it into the rules as well.
Okay. Right. It should be easier to be able to discern now. Well, at least if you went and testified at the public hearing. I mean, if a DES representative came before your subcommittee and you told them of issues that you thought were there and they don't address it, then there are certainly political ramifications that can be made, but you won't know until you read the rule whether or not they made those changes or why they didn't make the changes.
If I may, just one last.
Please.
And the public hearing that's coming up on the 20th in regard to the 800 rule has been scheduled from 1 to 4 o'clock in the afternoon. In talking with my colleagues, we don't feel like we should take the public's time to testify because,
Understood.
frankly, it was scheduled with insufficient time for the number of people who want to speak. So that's just one occasion where I don't feel like we're getting through.
Yeah. There is a statutory provision that says if there's not enough time at the hearing for everyone to be heard, the agency can continue the hearing. They file a form with our office, specifies when the additional meeting is going to be held. Likewise, if the weather is atrocious and they can't get the meeting or get a quorum, et cetera, it can be continued. If they realize there's going to be 100 people showing up and they just were using a boardroom, then they can also change the venue.
Thank you.
Representative Tenza.
So yeah, just following up on what you just said, there's been some folks that have already reached out to, I have as well, to DES concerning that, just to say that, because we know that, that's not going to be sufficient.
Yep.
Should we you know, in a sense, you know, whether it be our subcommittee or our committee, you know, maybe have a combined letter to DES to say, hey, you should really extend this time or whatever. I'm just asking your opinion. Or should we wait? I mean, or we could do both. They might not respond, who knows, or change it. Or should we wait until if there is a lot of people there and feedback that we wait for it to be, you know, extended? What would your advice be to us about that?
Personally, I think I would recommend both, because if you do the letter and they don't respond, and then there are 10 or 15 people that don't get heard at the public hearing, then the Jellicoe is going to take that much more seriously because they had been informed that that might be a problem.
Let's do that. Yeah. Perfect. Thank you so much for that. That's great.
Yes, sir.
Thank you.
Representative Germano.
So, and I'm thinking about, you know, how we might want to change these processes going down the road, as my colleague has some legislation and good legislation to do that. So under the current, kind of the way things currently work, so the legislature can pass legislation, have it vetoed by the governor. And then when it comes to the rule writing process, we can provide input to an agency. And the agency's response to us can be, well, we listened to you, but we didn't incorporate anything that you told us.
Yeah.
And in the end, the legislature ends up essentially powerless, correct? Because we tried to change the law. We're required effectively in this situation to have a supermajority to pass any law because it has to be veto proof. So we tried to change the law, we couldn't. And then we give feedback to an agency and the agency says effectively, thanks, but no thanks.
Yep.
So my question, do I have that right? I mean, it feels like the legislature is pretty powerless when it comes to actually affecting the rule writing process in a substantive way.
That's true, but my experience has been that executive agencies ignore the legislature to their own peril.
I hope that's true. I hope that's true. But thank you very much. I appreciate that.
And,
I like that. We're going to quote that. No, I'm just kidding.
and there is a requirement that the agency give due consideration to public comment. They are not required to make changes because of that comment.
Any other questions?
I like Peril. Let's add down Peril.
Hey, thank you so much for your preparation and your detail and your candor. It was very helpful.
Okay, certainly. And if you have any questions, give me a call.
Great. Thank you so much. We may
Okay,
in the couple weeks.
okay, thank you.
Thanks. I appreciate it.
Particularly if you have any questions about this particular rule that's going to come up.
Yeah, absolutely. I've got it. Thank you. Meeting is now adjourned. Thank you, Mr. Morrell. Appreciate your attendance.
Thank you.